Welcome to my page. Here I will help you with your property journey. The Renting Homes Act 2016 represents the most significant transformation of rental law in Wales for decades. And if you're a landlord operating in Wales, this legislation fundamentally changes everything about how you manage your rental properties. Coming into effect on December 1st, 2022, this isn't just another piece of housing legislation you can overlook. It's a complete overhaul that affects every aspect of your landlord responsibilities, from the tenancy agreements you use to how you handle evictions. The most fundamental change you need to understand is that the Act completely scraps the old assured short-hold tenancy system and introduces two new types of occupation contracts. Standard occupation contracts replace assured short-hold tenancies and are what most private landlords will use, offering similar flexibility to the old system, but with significantly enhanced tenant protections. Secure occupation contracts replace assured tenancies and provide greater security of tenure typically used by social landlords. This shift means all your existing documentation and processes need updating immediately. One of the most critical requirements is the enhanced written statement mandate. Gone are the days of basic tenancy agreements. The Act now requires comprehensive written statements that must be provided within 14 days of occupation beginning. These statements must include specific information about rent amounts and payment frequency, detailed property descriptions, complete landlord and tenant details, occupation dates, any fundamental terms that differ from default provisions, and comprehensive information about deposits and their protection. Failure to provide these detailed statements within the 14-day deadline can result in significant penalties and give tenants grounds for legal action. The Act introduces stringent fitness for human habitation standards that go far beyond previous requirements. As a landlord, you're now legally obligated to ensure your property meets specific health and safety criteria throughout the entire tenancy period, not just at the beginning. This includes maintaining adequate heating and ventilation systems, ensuring safe electrical installations, providing proper drainage and sanitation, maintaining structural soundness, and keeping properties free from serious damp or pest infestations. These aren't just recommendations, they're legal requirements, and failure to maintain these standards can result in substantial penalties and give tenants grounds for compensation claims. Perhaps the most shocking change for many landlords is the revolutionary notice requirement system. For standard occupation contracts, you must now provide a minimum of 6 months' notice using a Section 173 notice, which can only be served after the first 6 months of occupation. This represents a dramatic increase from the previous 2-month notice period and means you need to plan well ahead if you're considering ending a tenancy for legitimate reasons, such as selling the property or undertaking substantial renovations. This extended notice period significantly impacts cash flow planning and property management strategies. The Act also introduces revised rounds for possession categorized as either mandatory or discretionary. Mandatory grounds include situations like serious rent arrears, where at least 2 months' rent is owed, while discretionary grounds require court approval and include issues like persistent late payment or minor breaches of contract. Understanding these grounds is crucial because courts now have greater discretion in possession cases, meaning you'll need stronger evidence and more compelling arguments to support your claims. To ensure compliance, you need to take immediate practical steps. First, review all existing tenancy agreements and update them to meet the new written statement requirements. Remember that tenancies beginning before December 1st, 2022 automatically converted under the new system, but you still need to provide compliant written statements. Create standardized processes for issuing these statements within the 14-day deadline, maintain detailed records of all property maintenance and safety checks, and ensure all deposit protection arrangements comply with updated requirements. The financial implications are significant. Compliance requires more comprehensive documentation, potentially more frequent property inspections, and higher administrative overhead. The 6-month notice requirement means longer periods between deciding to regain possession and achieving it, affecting cash flow, especially when dealing with problematic tenants. The Act introduces substantial penalties for non-compliance, including potential rent repayment orders and significant fines for fitness standard breaches. Common pitfalls include using inadequate written statements that don't include all mandatory information, misunderstanding the complex notice timing requirements, and neglecting the enhanced fitness standards throughout the tenancy period. Many landlords underestimate these requirements and face costly consequences later. The Welsh rental market is still adapting to these changes, and landlords who embrace compliance and implement robust systems are positioning themselves for long-term success. This legislation aims to improve the overall quality and professionalism of the rental sector in Wales, and by understanding and embracing these requirements, you're not just avoiding legal problems, you're establishing yourself as a professional landlord who provides high-quality accommodation and service. Thank you for watching this video. Please subscribe to the channel so you don't miss the next video, and if you found this useful, please like it or share it with friends and family who would benefit from the content.